Members out there, it is 1:35. We're already behind schedule. So we're going to call this special joint hearing of Proposition 26. I am joined by my esteemed Senate Revenue and Taxation Chair, Ms. Wolk. Thank you for putting this on. Did you have any opening comments you'd like to make? No?
I defer to you.
Okay, she defers to me. Prop 26 obviously is an initiative that is a constitutional amendment which will appear on the November 2nd ballot. It, in brief, would expand the definition of tax to include many state and local government charges currently classified as fees. And as a former local government official, that gives me some pause for some concern, so I'm looking forward to hearing some of the justifications for doing that. And this hearing is held under the Elections Code that we must do before the election. So with that, we are going to go right to our first panel, which is an overview of Prop 26, and we have Catherine Freeman, Principal Fiscal and Policy Analyst, Legislative Analyst Office, Marianne O'Malley, Director, General Government Section, Legislative Analyst Office, Michael Colantuno, a friend from local government days. How are you? And a fellow Italian, partner of Colantuno and Levin. And please, I got all three. See? She's telling me I didn't get all three. Please give your testimony. We appreciate you being here.
Thank you very much. My name is Catherine Freeman. I'm with the Legislative Analyst Office, and I'm going to be giving an overview of the initiative. As has been mentioned, our office's role in this is really to provide a nonpartisan analysis and a fiscal estimate of what the initiative would cost. And so today we're here just to provide that overview. If you have a lot of questions, we can answer them. We can also defer to other folks who are going to be here who are both proponents and opponents. So we do have a handout, and we can go ahead and start if you'd like. So starting on page 1, we wanted to look over the main components of Proposition 26, and this is going to provide the basis for most of our testimony today. First of all, the provisions include expanding the scope of what is a state or local tax, raising the approval requirement for some revenues, and then also avoiding inconsistent laws. And that's a unique clause in this measure that we'll discuss at some length a little bit further on later. So in order to understand how this law or how this initiative would change law, we first need to understand what are the existing categories of fees, taxes, and charges. And so on page 2, what we tried to do is give you an overview of the types of revenues that we receive in the state and local governments and what the examples are of what they are existing. So first of all, we have taxes, and that's the broadest type of revenue. And generally, unless there's a provision that says that you must not or cannot use them for another purpose, they're used for very broad purposes, and they're sort of the go-to revenue source. General activities, few restrictions, education, prisons, the like. Second of all, and narrowing the revenue stream a little bit, are user fees. And those are the types of things that you could consider park fees or garbage fees. Those are for specific programs, and they're generally passed by a majority vote, which we'll discuss later. The third are regulatory fees, and this is a little bit more from my realm, but this is the environmental fees, the fees that pay for environmental impacts. They're not restricted to the environmental resources, but those are generally where you find those types of fees. They're for programs and for services, and they're very specific to the types of regulatory programs that you can have. And then the last is property charges, and these are assessments that benefit a property owner. Generally, these are seen in the local areas, and a developer fee might be the type of fee that you see there. So on page 3, we have a table that's just a simple, quick guide to the existing fee and tax requirements at the state and local level. And what I'd like to say about this is that, and this is, again, we're sort of doing a general overview. In general, state or local governments can pass a fee with a majority vote of the governing body, so legislature or local governing body. For a tax, it's different, and it requires a 2/3 vote of each house of the state legislature or a vote of the people for local taxes. And then I think is fairly well known for most folks. And so the question is, well, what is this initiative going to do? Before we get to that, we want to look at what is a regulatory fee, because there's been some disagreement over time on what a regulatory fee is. And the disagreement surrounds the idea of when we have a regulatory fee and it pays for a broad array of services or broad public programs. And so I'll just go over briefly one of the defining court case that sets apart what is a fee and what is a tax. And this is just the guideline that folks use now because it went to the Supreme Court. So first of all, the Sinclair paint. In 1991, legislature, the state imposed a regulatory fee on companies who had used lead in their paint. And the money was used for lead poisoning programs. Well, Sinclair Paint argued that this was a tax because the programs were very broad. It was not a benefit to the regulated business, and the companies that paid the fee had no duties to the lead program. They didn't win at the Supreme Court, and so what does this mean? The legislature could enact this type of fee, broad-based fee, with a majority vote. The Supreme Court decision really provides the guidance for the legislature and for others who are imposing fees and taxes on where that border is between a fee and a tax. So we turn to Proposition 26, which essentially is a measure to change that definition in part. So there's three provisions that we're going to talk about, and I'll probably repeat these a few times, but these are the main provisions. First, it expands the scope of a state or local tax, as we said. It changes the approval requirement for the state revenue proposals, and it repeals recent and inconsistent laws. So the types of fees and charges that would be subject to the approval requirement are ones that the government uses to address health, environment, and others. And these are those broader-based fees that we discussed. Now, it's not all of the fees that we've passed in the past that have been enacted in the past, but those that were enacted between January 1st of 2010 and going forward. Certain regulatory fees could be considered taxes because they pay for those broad-based services. And there's other fees or charges that could be considered taxes under the measure. On page 6, we have a couple of examples of what are some regulatory fees that benefit the public broadly, just so you have some specific examples of what we're talking about. Oil recycling fees, fees on alcohol retailers, and then also hazardous materials fees. And it's good to look at what does constitute a broad-based fee. And there is some question as to, well, would these be considered taxes under the measure? We think likely yes. And so, for example, for the hazardous materials fee, this is charged on folks that treat or dispose or recycle of hazardous waste. There's a lot of businesses in the state that do this, from large businesses to very small ones. And the money from that goes to a broad array of services, from toxic waste sites to pollution prevention to education. It's very broad. That's the type of fee that has been passed, that was enacted in the past, that we think would be subject to this. However, it's very important to note that unless the state or local government increases or extends a fee or charge, the measure does not affect state fees or charges passed before January 1st, 2010. And there's no provision for local fees. So any local fee that's passed before November 2nd, 2010, or the election day, would not be subject to this. So that's sort of a window that we need to look at. So on page 7 of your handout, we look at the approval requirements for state tax measures. And under current law, it takes 2/3 of a vote of each house of the legislature to raise a tax, to raise revenues in a tax. Under current practice, though, and we're going to talk about this a little bit in terms of the gas tax swap, what's happened is that if you have two taxes that affect the same person or entity or being, and the legislature has raised one and lowered the other, but the net effect on the same person is 0, we have considered that to be a majority vote. Under this law, any time a fee goes up or a tax goes up, it must be voted on by 2/3. It has to be a 2/3 vote. So it is an expansion of the approval requirement. So we've discussed the repeal. There's a repeal requirement so that any law that was passed between January 1st, 2010 and the election day has essentially 1 year to be either voted on again by the legislature and passed by a 2/3 vote, or it will be repealed. And that's only those provisions that fall under the measure. So, for example, the gas tax swap. In spring of 2010, gasoline suppliers had decreased fuel tax. I'm sorry, I'll probably get this wrong. State taxes on gasoline suppliers were increased, while other fuel taxes paid by sellers were decreased. This is that meeting point. So the net effect, if I drive my car up to the gas station, is I have no idea that anything has changed. What it did, though, is it gave the legislature a little more flexibility to spend towards their priorities. This law would need to be revised under the measure and would be subject to a 2/3 vote. And specifically, that would change our net fiscal effect. Are there other recent laws that would broadly benefit folks that are fees? Probably yes. We have a few examples, but to date, we don't have all of the laws that have been that have been signed by the governor. So finally, an important part of our job is to look at the fiscal effect of Proposition 26. Because this expands the scope of what's considered a tax, we do think that revenues would be decreased, and we do think that there would be a fiscal effect that would depend on future actions of the legislature, local boards, and others. We estimate, because of the reduced government revenues, spending statewide would be up to billions. It would be up to billions of dollars for a fiscal effect. In order for us to come up with that estimate, and we can only estimate at this time, we needed to go back about 10, 15 years to look at what we'd already done and project forward. And it's not perfect. Our analysis is the best that we could do, and we've been fairly clear with how we used our methodology. Secondly, because this voids some inconsistent laws, we think that the state general fund cost of at least $1 billion would be, state general fund costs of about $1 billion would come to be because of the recently enacted gas tax swap, unless it was voted on again by both houses of legislature under a 2/3 vote. So with that, I can answer questions, or we can go to the further overview.
The background of this proposal is, of course, the Sinclair Paint case, which the LAO staff has summarized for you. The essence of what Sinclair Paint allows the legislature to do and allows local governments to do is to adopt as a fee a charge on economic activity that bears a reasonable relationship of the impacts of that activity on society, and to treat that as a fee, not a tax. But the amount of the fee in total must be proportionate to the cost of mitigating those social impacts, and the amount of the fee that any fee payer pays must also be proportionate to their share of the problem. So the lead paint fee, an issue in Sinclair Paint, was imposed based on the lead content of the paint products and the other lead-containing products that were subject to that fee. Two other cases that discuss fees in the neighborhood that we're talking about are the San Diego Gas and Electric case from 1988, by which the Air Quality Pollution District in San Diego County charged for its regular emissions permits, its general permit for emitters in that air basin, based on the pounds of pollutants emitted by the permittee, rather than a flat fee that reflects cost. Large emitters paid more than small emitters, and so there was an incentive to reduce emissions. And in another case that gives us an example of the kind of fees that Prop 26 affects is the recent case of the California Building Industry Association versus the San Joaquin Valley Air Pollution Control District. And that district imposed a fee on new development measured by car trips and tailpipe emissions. And the development industry challenged that, saying it had to be approved as a development impact fee. And the court said, no, it's perfectly fine under the Sinclair Paint. So that's the kinds of fees that are the subject of this discussion. Some of the recent proposals that touch on this subject are a number of agencies have talked about a fee on sweetened beverages to fund anti-obesity and public health programs on the model of what's been debated in New York State and New York City. Fees on alcohol to fund police and social services arising from alcohol consumption, like the fee that Mayor Gavin Newsom vetoed last week. Pertinent to this discussion is Proposition 21, which imposes a charge on vehicle license fees to fund state parks. I anticipate that there will be a fight over the validity of that measure if they both pass. The proponents of Prop 21 say it's a tax, and therefore it doesn't matter whether it's recharacterized as a tax by this measure. The opponents of Prop 21 can be expected to argue, no, it was approved by the voters as a fee, and under Prop 26, it's unconstitutional. We'll see how that plays out. And then, of course, the proposals regarding the total revenues collected by the state on gasoline is also germane to this discussion. So with that background, what does Prop 26 do? We do not have a definition of tax in our Constitution for the legislature. We have a definition of tax that the legislature gave us when implementing Prop 218 in the Omnibus Implementation Act of 1997. And that measure is pretty comparable to what Prop 26 would do. Anytime you pass legislation which makes any identifiable taxpayer pay more, even if the net effect of the whole legislative package is revenue neutral, it's going to be treated as a tax and require 2/3 of each chamber unless we can find an exception to cover it. Retroactivity has been discussed pretty well. I won't dwell on any further. I do want to talk about the exceptions from the definition of tax, which are really the heart of the measure. And there are 8 of them. One is there's an exception when you charge a fee for a specific benefit conferred or a privilege granted directly to the payer. We don't know what directly means. That'll get litigated. That is not provided to those not charged, provided that the fee is limited to the reasonable cost of providing that benefit or privilege. The example here is going to be a professional license or a land use approval by a local government. The second category is for a fee for a specific service or product, again provided directly to the fee payer, not provided to those not charged, and limited to the reasonable cost. The model here, I think, is a park and recreation fee, a fee for medical services, inspection services, and the like. That language about not charged to others, that others don't get the service for free, may be problematic for senior and low-income discounts for these services, and we'll talk about that more. The third category is for reasonable regulatory costs. For the state, it's incident to, and for local government, it's for. I don't know why they're using different language, and we'll end up litigating those slightly different prepositions someday. For issuing licenses and permits, performing investigations, inspections and audits, enforcing agricultural marketing orders. That's in the local government section, even though we don't enforce marketing orders in local government. And administrative enforcement and adjudication. What does it leave out from our regulatory universe? Rulemaking and advanced planning services. So it's not clear how we will fund those services going forward, whether those will have to be borne by the taxpayer or whether we can persuade a court or a court will decide that that's a reasonably incident cost of regulation. The next exception is for entrance to government property, and there's an express exemption for anything that has to do with the vehicle license fee. They're referencing that section of the state constitution. I think the proponents of Prop 26 will argue that their measure is inconsistent with Prop 21, and that if 26 passes with more votes than 21, that 21 is a dead letter. The Attorney General has opined that Prop 21 imposes a tax and not a fee, and therefore is unaffected by Prop 26, and that's one of those questions that the courts will have to resolve. The next category is fines or penalties imposed by the state judiciary or local government. Well, that means that a fine for violating a state regulatory regime can only be imposed in court. Where are they typically imposed now? In the administrative agencies, the Regional Water Quality Control Boards, the Air Resources Board, the taxing agencies, and the like. It looks to me that on the face, we've had a massive shift of adjudication from the administrative agencies to the courts. I'm not sure that the administrative agencies will appreciate the loss of means to enforce their laws. I'm not sure the judiciary necessarily has the resources, particularly in this environment, to step up to that increased caseload. And I'm not sure that the regulated community necessarily wants every fine dispute to be in the superior court as well. So I think there's going to be some discussion about what that means and what its implications are. The last two are less problematic. There is exemptions for development impact fees, and then there's an exemption for local government assessments and property-related fees governed by Prop 218. There is a statement about the burden of proof in this measure. It says government bears the burden to prove that their fee is within one of the exceptions and that the amount of the fee is below that cost ceiling. In general, I think that's helpful because the burden of proof that's articulated is the preponderance of evidence standard, which is the lowest standard of evidence that the courts ever demand of a defendant in a case. So in general, from a government perspective, the burden of proof rule, I think, is clarifying and helpful. So there's some open questions about Prop 26 that I think we're going to hear more about in the campaign and more about in the courts after the campaign if it passes. First, what is meant by the requirement that a fee be, quote, proportional to the benefit or burden experienced by or imposed upon society by the fee payer? That benefit of language is assessment language. It comes from language involving local government assessments on property provide services which benefit property. Transporting that benefit language into the fee context doesn't make a heck of a lot of sense. If you took it literally, Long Beach, which is a municipal gas provider like Palo Alto, would have to charge the local hospital more for gas because the social value of a hospital's use of gas is higher than me using it in my backyard to fry some hamburgers. I don't think we can get to the benefit of the use of a service in any meaningful way. I don't think it means that, but what it does mean remains to be sorted out. The next open question is, will the requirement that a service or product for which a fee is imposed not be provided to others not charged endanger discounts and free services to the elderly and low-income families? Park and recreation fee discounts are very common. Free admissions for these socially benefited groups are common. Gas and electric rate subsidies. Prop 218 was very careful to carve out gas and electric. This measure does not. So just as Prop 218 required us to get voter approval at the two-thirds level to maintain low-income and senior discounts for water, sewer, and trash, we probably have to do the same thing now for gas and electric when provided by a municipal utility, not when provided by a for-profit utility. In addition, for-profit utilities, by definition, are entitled to a profit. If Prop 26 passes, local governments that provide gas and electric services will face a cost limitation gap. So Prop 26 has, I think, very significant consequences for social choices about who's the best provider of these utility services. And you may find the private sector gaining market share at the expense of the government sector over time as the implications of these rules play out over time. Next area of open questions, how do we fund rulemaking and advanced planning services? I touched on that earlier. There is certainly going to be some the structure of the measure is that they define a tax for the state and they list exemptions. They define a tax for local government and list exemptions. The same list, nearly verbatim. And when two sections of a law are nearly verbatim, a court assumes that the lawgiver intended any trivial difference to have meaning. Well, finding out what the meaning is in Incident 2 versus 4 is going to scratch legal heads and generate legal fees for a while. And there's a half a dozen of those unexplainable slight distinctions. And then the last sort of area of open questions is this gas and electric problem about lifeline rates, discount rates, et cetera. What do I view as the major impacts of Prop 26? From where we sit now, we don't know what we will know, but given what we know today, certainly it's the end of Sinclair Paint. Certainly it's going to cause some litigation about the effectiveness of Prop 21 if they both pass and 26 gets a larger share of the vote. I think there's a risk to franchise fees at the local government level, pipeline fees, cable television franchise fees, and solid waste franchise fees, because we'll have to justify those fees as based on a cost we incur. Maybe we can justify them as a benefit we provide. Maybe we can justify them as for the right to use government property. But many of these facilities are provided in rights of way from which we can exclude no one. So I think we can probably win some of those fights, but I anticipate that we're going to have to. So those are large and important revenue streams to local government, and I think they're endangered by Prop 26. Pre-existing fees like the lead paint fee in Sinclair Paint, fish and game fees on local government for reviewing CEQA documents are grandfathered. But they're grandfathered under existing legislation, and you can't change that legislation without treating it like a tax. And if that existing legislation does not create room to incur increased costs with inflation, then those are going to be declining revenue streams over time. And then lastly, I think one of the major impacts is the senior and low-income discount issue, which I've discussed previously. And with that, unless the panel has any questions, I'm done.
Any questions?
Right now?
Yeah, from the panel. Right? You're not speaking, right?
Yes, I do.
Madam.
I just have a couple questions I wanted to address to you, and that is, in this area of the last year, that is sort of including the gas tax swap, in which we'd have to figure out whether or not, assuming this passes, we'd either have to consider it a tax and therefore pass it with a 2/3 vote in the legislature, or it's gone. Right? Okay. In addition to the gas tax swap, what about SB 401, which was the conformity bill passed by a majority vote? What happens to all of that? The mortgage relief, there were solar credit, there were all kinds of things in there. It was 110 pages of tax changes, some higher, some lower.
Yeah. Marianne O'Malley with the
Hello,
Legislative
Marianne.
Analyst Office. Hello. Any measure that increases a tax on any taxpayer, even if the aggregate effect of the measure is fiscally neutral, but if it increases the tax paid by one taxpayer and gives relief to 100, it would be void under this measure if it passed during this calendar year. Now, the legislature could override that by passing the measure again with a 2/3 vote of both houses of the legislature.
But failing such a vote, that measure sunsets in 12 months after the effective date of Prop 26, or November 3rd of 2011.
So if this measure, I'm sorry.
No, go ahead.
If this measure were to pass, we would go through a process of looking over all the recent legislation at the state level, both in terms of fees and also in terms of taxes, that would need to be reviewed to see whether it increased any tax as defined by this measure on any taxpayer. And that would be one of our first tasks if this measure were to pass. We've identified for you the largest one, the one that is clearest, which is the gas tax swap, where we increase the tax on suppliers and decrease the tax on gasoline retailers. Aggregate effect, as Catherine Friedman said, was neutral to me as the person driving up to the gas station with my car, but it did increase the tax on any taxpayer, and so therefore would be voided under this measure unless reenacted.
So let me talk about the conformity bill for a moment. We had debt relief involving short sales. If this is eliminated, and we cannot muster a 2/3 vote to continue it, what happens to those homeowners? They're going to have a big tax bill.
I can say that we looked at that one in particular and be able to respond to you on that one. But if it did indirectly result in that taxpayer paying a higher tax, and that's the broad language,
No, it didn't. It gave them relief.
Any taxpayer paying a higher tax, and that could be done many different ways in terms of changing deductions and exemptions, and many other factors can result in a taxpayer paying a higher tax. So any measure that the legislature passed that had that effect, we would be bringing back before the legislature, and you would be able to continue it upon a 2/3 vote.
I have one other question, and this is about the effect on the local government. Having been a mayor and on a board of supervisors, I don't quite understand. I'm sitting on a city council. I've got in front of me at budget time 3 pages of fees. Baseball team who wants to use the field. I mean, what happens to these fees? Part of that fee, at least in the city I served on the council, part of it goes to some kind of improvement of the field, maintenance as well as improvement of the field. Does that then become, do we have to have an election for each of those fees?
We are going to have a burden to cost justify our park and recreation fees that we've not had before. At present, when you set a park and recreation fee, a local government can set whatever fee the market will bear. Because it's not a mandatory service, nobody must consume it. At a certain level, we're in competition with the private sector. You can go to a private gym if you want to, a private batting cage. So we just set fees that are appropriate in the light of what our community's needs are. We have to use that money for the benefit of the Park and Rec program, although some cities that have very valuable Park and Rec programs actually make a profit which goes in their general fund, and that's perfectly lawful. When we set fees on development and when we set fees that are mandatory, we generally have to do a cost justification. That frequently involves hiring a consultant to do an economic study to demonstrate what your costs are. We are going to have that burden to demonstrate that every Park and Rec fee, every library service fee, every fee for a service is now going to have to be cost justified. And how expensive and how detailed the analysis is turns on, quite frankly, your business judgment as to what your level of risk is.
Thank you.
Question on, so if we improve tax collection, that triggers somebody paying more taxes. So would laws or regulations to improve tax collection or regulating tax shelters, would they then become 2/3 votes? Because in theory, if you're improving tax collection, a taxpayer is paying more?
Let me tell you what we know, and then let me tell you what we don't know with respect to the question. We certainly know that any change in the theoretical liability of a perfect taxpayer who never missed a penny they owed us, any change in that amount is a tax increase that's just going to require 2/3 approval of both chambers of the legislature. We also know that any enhanced effort to chase the guy who's not paying every penny of his taxes, or the gal, any law enforcement or administrative activity to enforce the same amount of liability that are already defined by law is not going to be a tax increase that requires 2/3 approval in the legislature. Where the gray area is, and what can be problematic, is that a typical piece of legislation that involves a tax or a fee has many administrative provisions in it that talk about when you file your returns, who reviews your returns, what the penalty for a late return is, what the consequence of lying on a return is, all of those administrative details. Well, we're now open to argument that enhancing those administrative penalties or changing the way that we administer them is a tax increase that requires 2/3 approval in the legislature. For local government, the legislature has given us a standard in the Prop 218 Omnibus Implementation Act, which says any change in the administrative methodology by which we calculate a tax is a tax increase which requires 2/3 voter approval. And so we've had some litigation of that. In fact, I handled a case for the city of Los Angeles involving their cell phone tax. We have some sense as to what that means. 26 has not adopted that standard and has not applied it to the legislature. But I anticipate that if 26 passes, that you will see arguments that you have that same administrative methodology kind of notion coming your way. So we know some things and we don't know others, and your question nicely points out one of the areas that's going to be disputed.
What about raising minimum wage? That would mean the taxpayer would be paying more taxes on increased wages.
I think you can argue anything in this free country of ours, and if you've got a filing fee and you're willing to show up at the courthouse,
we couldn't raise the filing fee without 2/3. So.
You could raise the filing fee if you could.
That was a joke.
Sorry, the lawyers can be literal.
Yeah.
You have to explain it. It's not much of a joke.
Yeah.
Touche, my learned vice chair.
I'm afraid I've lost track of the question. Raising the minimum wage.
Raising minimum wage, because that would weigh the broad interpretation, anything that raises the tax burden of an individual. Right. And so if you raise the minimum wage, by definition, that person is paying an increased tax.
I think there is the courts have recognized a meaningful difference between laws which regulate economic relationships between others and laws that regulate economic relationships with the state itself. So I think raising the minimum wage may have the consequence of raising payroll taxes, and we'll have some argument about that. But I would expect a court to conclude, no, you still have the power to regulate economic activity for the benefit of society. It's only affecting your budget that you can't do without a 2/3 vote of each house.
Okay. Any other questions of this panel? Thank you very much. We will bring up our next panel, which is the yes on 26. Mr. Velasco, Director of California State Relations from the Wine Institute. Mr. Dunlap, former Chairman, California Air Resources Board. I'll leave it between the two of you to decide who's going first.
I get to go first.
Okay.
I'm Mike Velasco. I'm with Wine Institute. We represent 1,000 of the California's 3,000 wineries and about a quarter of the 500,000 plus vineyards in the state of California. Thank you, Madam Chair and Mr. Chair, for the opportunity today to talk a little bit about Prop 26. Try to keep our comments as brief as we can, but to the point. Why are we doing Prop 26? We believe it's taxpayer reform, consumer protection, job retention, and safeguards the local voter approval. Prop 26 makes taxes masquerading as fees subject to a two-thirds vote of the legislature or vote of the local electorate. It would stop the taking of reserves from a special fund and using them for unintended consequences. That's taxpayer accountability and reform. Prop 26 is also consumer protection. If the intent of the levy or surcharge is an imposition on all consumers of a product for some consenting adults' irresponsible use of the product, then Prop 26 would protect consumers by defining these levies as taxes. Prop 26 is job retention. Let me give you a couple of concrete examples that affect our industry. Proposals to increase consumer fees on wine, beer, and spirits to fund alcohol recovery programs would be clearly defined as taxes under Prop 26. San Francisco Supervisor John Avalos' so-called drink fee that Mayor Newsom vetoed last week would punish consumers and cost hundreds of jobs. Assembly Bill 1019 by Jim Bell would have had the net effect of jacking up the price of a glass of wine for a consumer by $1.50. Sales would have plummeted in California, over $1.2 billion we estimate, and eliminated about 40,000 jobs between the beer and the wine industry. Prop 26 protects the local electorate's right to vote on taxes. Bell's City Council played fast and loose and raised all kinds of fees without voter approval to grossly inflate their own salaries. Prop 26 holds these local politicians accountable. The revenue raised by a fee must be commensurate with the service rendered. If not, Prop 26 makes it a tax, and the local voters get the final say. Prop 26 has no impact on legitimate fees for service, licenses, permits, environmental fines. We concur with the LAO that the fee on alcoholic beverage retailers is a legitimate fee. They're regulated for public nuisance and criminal activity around their premises. Because you're apt to hear something different from our opponents, let me clearly state Prop 26 maintains the ability of state and local agencies to impose all kinds of fees to regulate businesses and individuals for services rendered to the regulated community, but nothing more, and also to protect the environment. At this point, I'd like to turn over our share of the testimony to my colleague John Dunlap, the former chair of the Air Resources Board. Thank you very much.
Good afternoon. It's a pleasure to be with you today. I wanted to focus my remarks this afternoon on addressing concerns raised by some of the opponents of the proposition on the false grounds that it somehow undermines California's landmark environmental laws and the state's ability to fund them, and will somehow compromise the state's ability to hold polluters accountable. I join with my colleague, Maureen Gorson, who's a former Cal EPA General Counsel and the former Director of the Department of Toxic Substances Control, who analyzed the proposition in great detail along with me. I'd like to make a few key points and then go into some details. Number one, it will not diminish the ability of the state's environmental agencies to implement and enforce environmental laws. It will not affect liability provisions in those laws to ensure that polluters pay for the damage they cause. There are a host of specific environmental liability provisions that are available to regulators in what I call the compliance toolkit that they possess today, and these will not be affected. It will not affect legitimate environmental fees. Legitimate fees like those that cover the cost of a service, for example, can still be passed with a majority vote of the legislature or being approved by local officials. Fees for things like driver's licenses and fishing licenses or penalties for violating the law are still considered fees under Prop 26. Let's talk for a moment about California's ability to enforce and administer its strong environmental laws. It will remain untouched by Prop 26. Despite some misleading claims of its opponents, Prop 26 does not impede or undermine California's landmark environmental laws. The measure merely defines the term tax more clearly in an effort to prevent state and local governments from passing taxes disguised as fees. Prop 26 does not define all or even most fees as taxes. Fees such as those for licenses or permits, I just gave an example or two, those for specific governmental services or products, those for fines and penalties, or those reasonable regulatory fees necessary to implement and enforce California's environmental laws are excluded from the definition of tax in Prop 26. Specifically, regulatory environmental fees that are charged to fund the state agencies and personnel needed to administer and enforce environmental laws, such as hazardous waste fees, oil spill cleanup fees, and fees related to the California Clean Air Act and Clean Water Acts, all fall under one or more of the exceptions in Prop 26 and are thus still treated as fees requiring only a majority vote under the measure. Prop 26 does not invalidate the primary purpose test for determining if a regulatory fee is a tax. The primary purpose test adopted by the California Supreme Court to determine if a regulatory fee is a tax will not be invalidated under Prop 26. If revenue is the primary purpose and regulation is merely incidental, the imposition is a tax. But if the regulation is the primary purpose, the mere fact that a revenue is also obtained does not make the imposition a tax. The primary purpose of a majority of California's environmental laws and their associated fees are for regulation, not revenue. For example, fees collected under the Oil Spill and Prevention Response Act, which I mentioned, are collected for purposes like facilitating and cleaning up oil spills and responding to the threats of a spill. The language is clear that the fees can only be used for purposes related to oil spills and environmental impacts. Therefore, these fees will not be affected by Prop 26, and increasing them in the future will only require a majority vote, as the current law requires anyways. What Prop 26 does do is define as taxes those fees that are not attached to a specific regulatory program. While Prop 26 will require these charges, to be passed by a supermajority vote, it does nothing to affect the status of California's existing and legitimate environmental regulatory fees, nor the liability provisions of environmental laws. Despite the wildly misleading claims of some of the opponents of 26, the two-thirds vote is not a barrier to pass or fund environmental protections. You might recall that the Oil Spill Prevention and Response Act passed almost unanimously, and the hazardous substance control laws passed with a two-thirds vote. Polluters still pay under Prop 26. Prop 26 ensures responsible parties who pollute or damage California's environment will still be held responsible and required to pay. The legislature's ability to require responsible parties to pay or to penalize those who have damaged the environment will not be affected by Prop 26. California's statutes to ensure responsible parties pay for the necessary environmental remediation and cleanups remain subject to current laws. As mentioned earlier, the Oil Spill Prevention Response Act holds any party responsible for the oil spill absolutely liable without regard to fault for all damages that arise out of or are caused by the spill. That, for example, will remain unchanged. There are numerous other statutes that ensure responsible parties pay for necessary environmental remediation. For example, costs incurred by agencies overseeing hazardous waste cleanup must be paid by the liable person or persons, and these are all found in the Health and Safety Code. So, in conclusion, there are several other California statutes that give the state power to fine or penalize those who damage the environment. We want you to know it's not the intent of the proponents to take away a valuable compliance tool or toolkit that they currently possess. None of the statutes that I mentioned, nor any future statute in their same vein, would be subjected to a supermajority vote as a result of Prop 26. So I guess I would say that the idea that this will somehow gut environmental protection in the state of California is something, in my reasoned opinion, is not completely true. Not true. Thank you.
Any questions of this panel? Mr. DeVore?
Thank you, Mr. Chairman. I have a question for Mr. Dunlap. I believe it was in December of 2008 when, as I recall, the Senate President Pro Tem, in response to the rapidly deteriorating revenue situation in the state of California, proposed something that I think was initially embraced by the governor, and then there was a bit of a back off because there was some argument within the legal community as to whether or not this could be undone, whether in fact it was in line with Sinclair Paint or not. And the proposal, as I recall, was to decrease fuel taxes and then basically substitute other taxes such that you had a revenue neutral impact, and then put in some sort of a congestion or pollution mitigation fee that had the net effect of raising billions and billions of dollars. If Prop 26 was in place, how would it impact, specifically from a legal standpoint, how would it impact such a maneuver designed to get around Article 13 of our state constitution regarding a 2/3 vote threshold to increase taxes?
Let me try, Mr. DeVore. It's our intent that those so-called swaps would not be permissible. That's consistent with the LAO said. It's highly debatable if they truly are revenue neutral, and other than the esteemed Ledge Counsel, I'm not aware of any other, legal giant that said that approach is really revenue neutral. Did I answer your question?
What's the specific mechanics? I mean, you say that it prohibits it, okay, but I'm hearing that you can raise fees that have a nexus with an actual impact on the environment. Okay, so
yes.
So if you look at the the legal theories surrounding pollution that affect everybody, the tragedy of the commons and how a polluter may receive a net benefit from his pollution that's then spread out over millions of people, each of whom may have a dime's worth of health impact on them. So that there's a health impact on that pollution. So how can one? I'm presuming that your intent is to, from what I've heard, is to continue to allow fees that do have a direct nexus to some
correct
activity that could be deemed harmful in the regulatory environment.
Yes.
So what I'm asking is specifically the specific mechanism. I understand that it's your intent to prevent the sort of swaps that were highly controversial in that proposed December 2008 budget deal. But what I'm wondering is, what specifically does Prop 26 do to prevent that if it in fact passes?
I wish I could cite the subsection in Proposition 26. I cannot do that.
Okay.
We'll have to get back to you.
All right. But I guess what I'm asking is, are you attacking the swap part of it that alleges to be revenue neutral, or are you attacking the fee whose real purpose is to raise revenue?
Well, both.
Okay.
Because in our opinion, it's highly debatable if it is revenue neutral. So if it isn't revenue neutral, there's somebody's paying more. And there has to be the causal connection. It's a causal connection to put a fee on wineries by the Department of Alcoholic Beverage Control to regulate us. But if that part of that fee was used to fund state parks, there's a disconnect there. And that's where the fee would become a tax, that portion of the fee. If the fee stayed, fee on the California food processors to be regulated by the California Department of Food and Ag so that they properly pay farmers, and that's all the fee was used for, that's a fee. It's not a tax. Hopefully I answered the questions. The direct nexus is very important.
Yeah, and the idea, too, is to prevent, to hand check those that would use the regulatory programs as a way to tax, to hide behind them.
Ms. Wilk?
Good afternoon. I'm sure you heard my questions before to the LAO, and I would like to pose them to you. The first has to do with this issue of the window of time in which anything that conflicts with the proposition, should it pass, those taxes, for example, the gas tax, would become null and void unless unless two-thirds of the legislature passed it once. My concern is with the conformity bill, which made a whole series of 110 pages worth of changes to tax code, some increasing and some decreasing. And overall, as a package, it was put forward. It was a majority vote. I'm not sure we could get a two-thirds vote. So I'm wondering what would happen to some of the important things that we changed in that bill, such as the mortgage debt elimination for homeowners. There were many other things.
I wish I could give you an answer, Ms. Molko, but I can't. I don't know the specifics of that legislation.
Well, what about the issue? All right. Well, Mr. Dunlap?
I would agree. We need to look at it and give you a determination.
Well, what about the issue of, again, I mentioned that I used to be in local government, so we're confronted, it's budget time, we have in front of us 3 pages of fees. What if you just need to adjust something for inflation?
For inflation?
Yeah.
Well, our alcoholic beverage control fees are automatically adjusted for inflation in law now, and that wouldn't change. It'd still be a fee.
But that's not clear in the initiative, is it? That inflation or workload adjustment would be changed?
I would agree with previous witnesses that you could probably, good attorneys can debate everything, but that's not the intent. We wouldn't be supporting it. Our industry is a very good example of partnership with government. More than half of the Department of Food and Ag's budget is fees on industry for a service rendered, or in the case of, as an alcoholic beverage manufacturer, to be regulated by the department so that we do not sell to minors and that we do comply with, whatever label requirements are. Those are legitimate, and it's legitimate to assume that there would be cost of living increases. And we know that the department sometimes runs and should run a surplus. We do not want them dipping down into, not being able to do their job. So it's not, again, not the intent of us as one of the co-sponsors of Prop 26 to say, oh, no, that ABC license, because they do have a revenue surplus, is now a tax, and, it's going to be 2/3 vote. Did that kind of answer your question for you?
Not exactly, because while I understand that it's your intent, but what I don't see is, unlike previous attempts to deal with this fee issue, tax issue, inflation, workload adjustment was explicitly excluded from or incorporated into the initiative or the effort. It's not here. So if I want to counsel, I don't know. I guess the attorneys would have to figure it out, but that would cost us a lot of money and a lot of time, and I just don't. It's not explicit, and it ought to be. I didn't draft it. Unless the drafters decided not to put it in.
I think what we will have is examples where certain industries or certain sectors within industries will say, oh, that's a tax now if Prop 26 passes. That may happen. But I can say to you for our industry that the ABC license fees, the Food and Ag Code license fees, are fees to us, so we're not going to ask, they're not going to be 2/3 vote. We don't want them to be 2/3 vote. Now, and we believe that it's a cost of service. If it's related to the cost of the service and not for something extraneous, then that would be a very good rule of thumb.
Ms. Walk, maybe I can give an analogy or perhaps liken it to something else. There's a particular regulatory agency in the Cal EPA family that has a compliance, enforcement and compliance program. As part of that program, they built a budget around 200-plus people, let's say, to do enforcement of regs and compliance assistance. And that's what their budget has been based on, those functions, for a number of years. Because of a reprioritization undertaken within the management of that organization, they have decided against the compliance education part, and they're after the enforcement part versus educating the sources subject to new regulations. That's the kind of thing that one has to guard against in government, that there'll be somehow a bait and a switch. They will even seek, in some cases, the legislature's approval. Some bureaucracies may, and you in good conscience may support that effort. But when it comes to implementation, it's bastardized or changed, or it's emphasized in other ways that other than its intended purposes and its justified purposes. So it's extremely difficult to be able to not just identify those circumstances, to protect against it going forward. And one of the things Prop 26 does, and one of the appeals it has to me personally, and I've been a regulator for 20-plus years, and believe in strong, firm, consistent environmental regulation, you have to provide the resources for their intended purposes. You can't bait and switch it. And I can tell you, there's examples of that, as you probably know, that happen more frequently than it should.
I understand what you're saying. And if this only applied to the state, not if, but what you're saying really, I understand it with respect to the state fees. What I don't understand, and I'm trying to understand, is the impact at the local community, having served on the council and on a board of supervisors. It just seems to me that the kinds of fees, the notion of public benefit, and I use the example of the
Right.
sports team. How do you determine whether there's a public benefit as part of what's being charged as part of your rec fee? I mean, because there is, arguably a public benefit to a portion of it would go to improve the fields.
Yeah.
And cities do that all the time. So I don't get that.
It seems okay.
I don't want to see cities have to go, and I'm not sure you do either,
Right.
for a 2/3 vote for these kinds of fees. I mean, that's a nightmare.
If it's the maintenance of the ball diamond that my son's team or daughter's team uses, that's legitimate. There's a direct connection there. You can't just build a diamond and it survive for 30 years without mowing the lawn and mowing the grass, whatever. But if they charge you a fee, and part of that fee is for unrelated purposes, then that's when you get beyond the gray area. If it's related to directly related to the activity, using that field, maintaining the field for use, then that stays a fee. But if you tack on a surcharge for the local homeless shelter as part of your fee to use the baseball diamond or soccer field, no, that's not directly connected. That's a tax. That part of that fee is a tax. So we're not talking about undoing the fee system we have in California. All of the fees by local and state government are based on causal connection, based on the primary purpose provision. It's the creative use of fees for other purposes that we'd like to bring to a stop.
Okay.
If I could follow up, it seems like there was a concern about nexus issues and a concern about revenue neutrality to create a majority vote decision. And my question is, and I think piggybacking on what Ms. Woke said, is what's before us or what's before the voter is a very, very broad piece of legislation that has much more, that encompasses much more than those two acute issues, with lots of gray areas and potentially unintended consequences and issues subject to interpretation. So my question is, from a public policy strategic perspective, why wasn't this issue just attacked from the nexus issue and the revenue neutrality issue, and work on, sound public policy definitions to address those two issues, versus this broad, encompassing piece of legislation? And I, as a local government person, certainly franchise fees, certain things that are the domain of local governments to negotiate, are going to be affected by this. I thought I heard LAO say that oil recycling and hazardous material fees would be captured. I think you may have said the opposite, so I don't know if there was a difference of opinion there. But it just seems like there was legitimate concern on two specific pieces, but yet we've got something before us that's the kitchen sink with lots of gray areas and definitions that define. So if you could comment on that.
I didn't write it.
Somebody did.
Yes. And I wish, Mr. Martino, I could give you the answer to the question. I can't. But it's not meant to be very, very broadly written. Why? Because there are a lot of the principal supporters of Prop 26 like legitimate fees. We believe there is a role for them.
Right.
We would not support anything that would undermine that ability. And for us, Pierce's disease program, every wine grape grower pays a fee because government helps them keep the pest down. That we don't want that to be a tax. Right. So, I believe that very good attorneys can argue that all these words will have brand new meanings. Some of them may, but it's our contention that it is not meant to be very expansive, with the net effect of crippling the ability of government and the regulated community to be served.
Okay. Any other questions? Thank you very much, panelists. We'll bring up our next panel. The No on 26 panel, Mr. Goldberg, Executive Director of the California Tax Reform Association, Bill McGavran, Director, Sierra Club, and Ed Carrig, Legislative Director for the League of California Cities. Gentlemen, if you could come up and tell us your views.
Madam Chair and members, thank you for having this. And I would point to, in your materials, the list provided by the proponents. And I had hoped that we would ask them the questions, because the proponents have listed not a nexus issue, but anything with a public benefit, even when there is a clear nexus. And so I would argue this is a deeply flawed and extreme measure. Precisely at its core, I mean, it has many other flaws, and I'll go through them briefly, but at its core, it says that you cannot provide a benefit, if you read the language, to those who are not charged. So the examples that they use are for arena and sports teams and promoters. You put on a rock festival, you cannot charge a fee for public safety cost mitigation and traffic impact. There's a clear nexus, but it's a public benefit. So this measure, if you look at their own list, oil spill prevention and response. They said, if you listen to them carefully, they said, oh, for cleanup, we'll have to pay for cleanup. Yes, but you cannot ask for a fee to create the preventive capacity, even when there is a clear nexus. So this is extreme because no public costs or benefits are allowed. It is not about nexus. And it's in their own proposals and in their own list. There are many examples they give where there is a clear and obvious nexus, but it still becomes a tax. It's flawed because, as you pointed out, it does not provide for inflation. Prop 37 provided for inflation. The answer you were given was the statute allows for inflation. That might be in a particular statute, but there are many, many, many statutes that are in which there are fees, in which there's no allowance for inflation. So clearly flawed on that ground, clearly extreme by not allowing current fees to be increased for inflation and workload. With regard to redefining tax fees as taxes, you can say it takes a two-thirds vote to increase fees, but they don't do that. They say it takes a two-thirds vote because they are a tax. So there may be 15 bills here that you have two-thirds vote on to increase the fees just for inflation, or for increased workload, and you will have members who will have to take 15 tax increase votes. Well, I don't think you'll ever get the two-thirds, not because they're an increase on fees. I've seen fees pass by well more than a majority, by almost unanimous votes. This is an increase in fee. All of a sudden, what they've done is redefine it as a tax increase, and as you know, one-third of this legislature is pledged not to vote for any tax increases. You can imagine they'll be run against having voted for 15 tax increases or 7 or whatever that number is. So that's another extreme. Then there's this question of the $1 billion hit on the budget, which, you know, if they wrote this, it is a year ago, when it became clear that they were doing a majority vote gas tax swap, which all it did is it got rid of the Prop 42 limitations on expenditures and went back to Article 19, gives the legislature a lot more flexibility, saves $1 billion for the budget. That passed by majority vote, not two-thirds. Now, any time along the way, the proponents could have said, oh, we don't intend to have $1 billion hit on the budget. Can we reenact that gas tax swap? They did not do that. So we have $1 billion hit on the budget, which I have to say plays to our favor. People don't think we should be increasing the deficit, but that was a very extreme measure that says something that gives the legislature flexibility ends up with $1 billion hit on the budget. I believe collections become more difficult. We passed abusive tax shelter statute. That is a change in state statute which results in any taxpayer, a single taxpayer paying a higher tax, raised billions of dollars, likely to be affected. Certainly conformity is obviously affected and will always be affected. We've always had conformity bills by majority. I looked it up. Senator Ashburn, who I thought was going to be here today, was the only Republican to vote consistently for conformity bills, so we would never be passing conformity bills except if we took some of those revenue increases that the Congress had put forward that we were supposed to conform to, unless we had taken them out. So I don't know about I think one thing you heard here today that is also about the extreme nature of this is the loss of senior and low-income discounts. I'm paying a fee. I should only be paying for my service, but we cannot give a senior discount out of the cost of that fee. But I really have to go back to square one. This is not about nexus. It doesn't say that. It says if any benefit is provided to the public. So oil spill protection, it has a phrase in here for pipeline. If a city or county may put a fee on pipeline for public safety, that would become a tax subject to two-thirds vote. A rock festival to pay for overtime for cops to protect the public, that would be a two-thirds vote. So I just think as you drill down in this, it becomes a very extreme measure.
Mr. Chairman, Madam Chair, Bill McGavern with Sierra Club, California. This measure is broad, it's sweeping, it's extreme, and it would lead to a morass of litigation. It would lead to shifting of charges from polluters onto the taxpayers. It's a direct attack on the longstanding principle that polluters should pay for cleaning up the damage that they do, because it would reclassify as taxes fees that are currently used to pay for cleanup of pollution, for mitigation of its effects, for research and deployment of cleaner alternatives, and for the operations of our state agencies. We've talked a little about Sinclair, but we need to look a little deeper at the Sinclair decision, because what that case did was to uphold the law that pays for the childhood lead poisoning prevention program. So is this what they're calling a hidden tax? Because that's what the court decided in Sinclair, that it was fine to put a fee on those that had made products that had lead in it to pay for the childhood lead poisoning prevention program. And yet these kinds of fees are being attacked by the proponents of Prop 26 as hidden taxes. They talked on and on about how what they want is to have a nexus between the fee and what the money is spent for. That's not in their language. The word nexus does not appear. That idea of the causal connection, that's not in the initiative. You know why it's not in the initiative? That's existing law. The Sinclair decision requires the nexus. The example that was given of a fee on ballparks to pay for a homeless shelter, that's already illegal. Sinclair covers that. You can't do that and call it a fee. The scandals at Bell, those are already illegal. That's why they were taken away to jail. Okay? So we don't need to amend our Constitution to reinforce existing law, and that's not what they're trying to do here. They're using that as a Trojan horse to protect big oil, big tobacco, who are funding this initiative. In the environmental area, there are the bulk of the programs at Cal EPA are paid for by these kinds of fees, and I'll run through just a few of them. Most of the Department of Pesticide regulation is funded by the pesticide mill fee. There's a fee on hazardous waste generators, provides much of the funding for the Department of Toxics. The underground storage tank cleanup programs, a fee on the storage of petroleum. E-waste recycling, a fee paid on the sale of the products that, the electronic products. The Carl Moyer program, which has done a lot to clean up diesel pollution around this state, is funded by fees. The AB 118 Alternative Fuels and Air Quality Program, funded by a variety of fees. That's giving us development and deployment of cleaner vehicles, of air quality, of replacing diesel engines, and that program will sunset. So it would, to be renewed, require a 2/3 vote if this were to pass. The legislature this year passed a bill to make a small increase in the oil spill fee. As far as I know, the governor hasn't made a decision on that, but if he were to sign it, it would be repealed by this, and that would go towards prevention of oil spills. Mr. Colantuno pointed out that this would even rule out fines that were not imposed by the judiciary. And I know in the environmental area, a lot of the fines and penalties are imposed administratively, not by the judiciary. So that opens a major can of worms. Obviously, you know, you can claim, oh, this wouldn't rule out that kind of a charge. It would just subject it to a 2/3 vote. Well, we know how hard it is to get a 2/3 vote. That's why we still don't have a budget. So we do see it as a virtually insurmountable hurdle, especially since, as Mr. Goldberg said, these would be reclassified as taxes. So everybody who took the no tax pledge, they'd be voting against something, I think, even if it had industry support, which some of these fees occasionally do. The conformity bills needing 2/3 vote, there are more problems with this, I think, than have even been brought out. It's clear why every major environmental group in the state is opposing this. It is a Polluter Protection Act. Thank you.
Mr. Carrick.
Mr. Chairman and members, Dan Carrick on behalf of the League of California Cities. I know a lot's been said here today. I know there's been a lot of people have already covered a lot of a lot of technical examples. I guess I wanted to kind of focus on three things. First of all, as Mr. Portantino pointed out earlier, the question was, well, why didn't you come with a more sort of narrow measure? I think we all know there was a lot of frustration, maybe with some interpretations that you could, lower a tax, increase another. There were questions about that. I think if to the extent there was a measure, I think we expected something about that, and clearly there would have been a debate about whether or not that was adequate. What we got is something so much broader that I think clearly the proponents can't really tell us what it will cover, as was evidenced by the prior testimony. As opponents, we're grasping ourselves to try to figure out what it really means. And I think certainly the voters are not really going to know what this means probably till many years afterward, after many court cases. There was discussion with the prior panel that, well, that isn't what we meant, or we wouldn't be for that, or whatever. We're talking about words that are going to be in the Constitution. While legislative or not legislative intent, well, the intent that maybe you may be able to find in a ballot statement or elsewhere may be helpful in interpreting it, as Mr. Goldberg pointed out, when you look at from their own website what they were telling their own members what they're trying to do. Now we don't think it does all this, but it sure is a pretty scary document to look at, to think about what they might have in mind that it might do. So there's going to be a lot of debate about that, and we're really stuck with the language no matter what people intended, because that language is going to be in the Constitution. When you look down through this list of what it is purported to potentially cover, and you look through whether it's health issues, alcohol, oil, if you really think about it, or at least as I've thought about this, one of the fundamental purposes of government is to protect the public health, safety, and welfare. That's kind of one of the reasons government sort of exists, is to look out for the broader interests of society. A lot of what's going on here is to the extent that efforts by government to address those issues become interpreted as, no, that's a tax issue, that's really putting a higher voter barrier associated with it. It's really going to limit what I think is probably one of our fundamental functions, whether it's a state or local level. This measure in itself doesn't do this. It just adds to a problem that I think we all know is out there that is harmful to the state, which is it continues an existing inequity in the way taxation and revenue authority exists between state and local government. We all know there's lots of arguments in Sacramento about whether you should raise revenue or not raise revenue and all those things, but you have the flexibility at the legislative level to raise revenue with a 2/3 vote and a governor's signature. Back at City Hall, if we want to raise revenue for a specific purpose, it's a 2/3 vote of the voters. That's a much higher hurdle. It's a much different level of accountability, and so to the extent that based on those existing limitations that we have, that there are there's a little bit of fee authority left here or there that local government has, and to the extent that this measure further constricts that authority by putting whatever other flexibility we have also to the 2/3 local vote threshold, it really curtails our authority much more than it already is. What does that mean? It kind of takes us back to the state budget discussion. There are, as we look at our needs of a state with almost 40 million population and all the other different issues we know going forward, we know there's going to have to be lots of investments in infrastructure and all sorts of things to deal with our service needs and other things going on. Now, how's that investment going to happen? It's either going to have to happen at the state level, which clearly the state doesn't seem to have the capacity for that right now, or local governments are going to have to take on more responsibilities, whether it's for infrastructure or other things. To the extent that we become more limited, that just puts us in a position where we either can take action locally, or we have to come to you at the state level and either, can we get some revenue to do this? Can we maybe support a statewide bond to do that? Because you have more flexibility than we do, and this I think continues that inequity and compounds problems. And the last thing, and I know this has already been said, we get questions as people are trying to figure out Proposition 26. Well, can you tell me what specifically this measure does? How does it specifically? Nobody can really answer that question, and it's really going to be years of litigation before we really figure out what this measure really does. And to the extent it's very broadly interpreted, it's going to be a very negative thing for our future. We hope, with hopefully the assistance of good attorneys, we could limit the damage, but it's certainly, we know it's going to restrict our flexibility. The only question is how much. So with that, it concludes my remarks.
Thank you. Any questions? I think you guys pretty much hit a lot of the concerns and commentary. I just one comment. I mean, Mr. Velasco obviously represents an industry with an acute issue, and I appreciate him being here. I'm a little bit surprised that the co-chairs of the initiative, who had a hand in drafting the language, didn't come forward. The California Chamber or California Taxpayers Association, it would have been good to have them up here so we could have, drilled down on some of the specific. I don't know if they're in the room.
Chamber's here. If I may, Mr. Chair.
Hold on one second. Is the Chamber here?
Do you have a representative from the Chamber? Or Caltax?
I see no hands go up.
Maybe they're embarrassed.
Okay. Madam Chair, do you have any closing comment you want to make? Do you want to make one?
Well, I just
comment, because I want to go to the public too.
Yeah, just that because this list was put out by the proponents, I would hope, and there are very few opportunities to actually ask the proponents if this is what they intend. I would hope we would take this opportunity to bring the proponents back and ask them if, in fact, this list represents what they expect that this measure would do.
It's also my understanding that the list, I don't think, is on the website anymore.
No, they took it down off their website.
It's been taken down. So, but thank you for that observation. If we have members of the public who want to come up and make a brief comment, please line up. You can take a chair or line up behind the podium.
Good afternoon, Mr. Chair, Madam Chair. Justin Milan on behalf of the local environmental health directors. And I want to echo the sentiment and frustration of the League of Cities, CSAC, and the rural jurisdictions that really feel this is a meat cleaver approach to an issue. I really want to express our frustration with this approach because, as many of you know, the local environmental health folks are the folks in the ground. That's where the rubber hits the road. They're the ones that are providing public health protection, environmental protection, and safety to the public on an everyday basis. Our programs are almost exclusively 100% fee supported. That means we don't have general fund coming down from the state or the feds. We rely on fees. And if we were to limit septic tanks or vector control to only those people that were getting a direct benefit, we cannot charge a mosquito for vector abatement.
You can squash them, but you can't.
We can do that. But the governor may give them parole. May give them a clemency. I just want to, in all sincerity, this could have a devastating effect on your everyday public health, safety, and environmental protection. Think of things like food recall. We don't have a fee. We can't charge a fee in a restaurant for a food recall. It comes from somewhere else. Think about underground storage tank, orphan sites. You got a major spill somewhere. We don't know who's responsible for it. We just got to leave it because we've got no bucks to clean it up. This is a potential travesty at the local level, irrespective of what these people are saying. Their great intent just to tweak the funding, this is going to have a major impact on the services at the local government level. And we hope that not only you, but the public trash it. Thank you.
Thank you.
Mr. Chairman, Madam Chairman, I'm Trudy Schaefer, representing the League of Women Voters of California. We also strongly oppose Proposition 26, and we thank you for having this hearing because we think it's very important that information about a measure like this be distributed and get out to the entire public. We're pleased that it will be available for people to watch and rewatch on Cal Channel. I don't think there's too much more I need to repeat. Definitely we believe that this is a very damaging measure. We object greatly to the fact that big oil, tobacco, alcohol industries are trying to shift the burden of paying for what they've done and what their businesses should be responsible for the costs of, to shift that burden onto the taxpayers. We as a league, a membership organization that has studied state and local finance for years, strongly feel that almost every finance measure you can think of should be a simple majority. And we certainly object to the use of a reclassification to require a two-thirds vote for all of these different measures as a way to make it almost impossible for such measures that would protect the public to be enacted. For all those reasons and so many others that have been stated today, we oppose.
Thank you.
Honorable Chairs, committee members, my name is Amanda Eakin. I represent the Natural Resources Defense Council. NRDC is opposed to Prop 26 for three main reasons. First, it would effectively eliminate state and local governments' ability to hold industry accountable for the harms caused by their activity. By redefining environmental and health mitigation fees as taxes, Prop 26 shifts the burden for cleanup of oil spills, hazardous waste, and air pollution entirely to taxpayers. Second, it would hamstring already struggling local governments trying to provide basic services and safety for their residents. Specifically, funding for public transportation has been decimated at a time when transit is needed more than ever to help people get to their jobs and to help California meet its greenhouse gas reduction goals. Prop 26 would force local governments to run costly elections and garner two-thirds supermajorities every time they want to provide some basic funding for public transportation through traffic mitigation or fuel fees, or when they want to address the traffic, litter, and public safety of major events. Finally, Prop 26 applies to any majority vote budget changes in 2010, including the gas tax swap enacted earlier this year. Although the gas tax swap did not increase allocations to public transportation, it did stabilize revenues available to transit agencies. If Prop 26 passes, funding for transit agencies would again be extremely volatile, and the state would need to figure out how to close an additional $1 billion hole. Thank you very much for your time and for your leadership.
Thank you, Madam Chair. And, Chairman, is it not on?
Now it is.
Okay, good. Thank you so much for holding this hearing and for helping get information about this important measure out to the public. We too strongly oppose Proposition 26, and you've heard a lot of the reasons already, but I want to make one point very clear. The important programs that are funded by fees, so addressing air quality impacts, water quality impacts, and other pollution cleanup measures, that's all work that has to happen. And if it's not paid for by the polluters that caused the problem, then it has to be paid for by the public. If that means increased emergency room costs and then increased health care costs for the rest of us, it's going to be paid for. This measure simply shifts the burden from the polluters to the public, and that's why we're vehemently opposed to it. Thank you.
Tell us who you are.
Sorry, Tina Andolino with the Planning and Conservation League.
Good afternoon. My name is Teresa Bui. On behalf of Californians Against Waste, we are opposed to Proposition 26. Proposition 26 will make it politically impossible for manufacturers to pay for the recycling and cleanup costs associated with their products. This includes toxic electronics, used oils to old tires. California has applied the polluter pays principles to the cleanup costs of product-based pollution. Without the ability to assign the actual cleanup cost of pollution to the manufacturers, waste will increase and costs will increase to the taxpayers and local government. For those reasons, we are opposed to Proposition 26. Thank you.
Hello, my name is Brandon Kitagawa. I'm with Regional Asthma Management and Prevention, and we too are opposed to Proposition 26. We're committed to an approach to protecting public health that prioritizes preventing problems before they arise. And I think what this proposition would do is essentially overturn the decision of the Sinclair decision by the Supreme Court that clearly establishes that the public benefit is a legitimate reason to collect fees, and that decision clarified and made it possible to do a lot of public health prevention programs. And so we certainly strongly oppose the proposition.
Good afternoon. Paul Neprath, representing the American Lung Association of California, and we are strongly opposed to Proposition 26. We were opposed to Proposition 37 in 2000 that was voted down by the public. We're hopeful that voters will see through the deception in this measure as well and vote against Prop 26. I guess from our organizational perspective and our mission to protect public health, this is a disaster. The fees that are used for prevention and enforcement programs in air quality mitigation, air quality and pollution cleanup, tobacco prevention, cessation, are critical for public health, and that's why our organization is strongly opposed to this measure.
Good afternoon. Jorge Castillo from the Marine Institute. I'm also here representing the Charts for Harm Alliance, an alliance of over 100 organizations statewide that are working to make the alcohol industry pay for the harms that alcohol costs in the community. We see this legislation as another tactic by the alcohol industry to continue their irresponsible behavior and not pay for their fair share of harm they cause to society. We've measured the cost of alcohol to the state to be $38 billion, and specifically $22 billion to the public sector. The alcohol industry hasn't had a tax increase since 1992, and that was of 1 penny, and it's lost a lot of its value due to inflation. So we just see this as a continuation of that process. And while programs and prevention and treatment are getting cut, the alcohol industry continues to make profits and evade paying its fair share. And the representative here from the alcohol industry cited San Francisco as an example why we should oppose the fee. Well, I would like to state that in San Francisco, we did do a nexus study that proved the costs between consumption of alcohol and how it was related to the harm, and we estimated $16 million associated with that nexus study. And there was an economic impact report done also by the Controller's Office that had a neutral effect to the city and county. So even though that took place, the alcohol industry continues to state that use the word nexus in their terms, and also to ignore the nexus and the neutral impact has been cited in, for example, in San Francisco. So for this reason, we would like to oppose Prop 26 on behalf of Marine Institute and the Charts for Harm Alliance.
Thank you. And our final speaker.
Good afternoon. I'm Jennifer Richard, Policy Director with the California Center for Public Health Advocacy, here in opposition to Prop 26. We see this initiative as an insidious effort on behalf of the tobacco, alcohol, and oil industries to take the power away from local governments to protect the public's health. And for these reasons, we're urging members of the public to vote down Prop 26 in order to protect the health of their communities.
Thank you. As a final thought, it is telling, it seems, that the co-chairs of the campaign didn't seem to show up. You might want to ask them why. Also, the handouts that were part of the presentations are all available on the Assembly's Rev and Tax website, so if anybody wants any of the materials, you can get them off the website. Ms. Wolk, would you like to say anything?
I'd like to go back to what you said in the beginning. And that was that this is the initiative is a very crude weapon, a blunt instrument for doing policy. And for both Prop 24 and Prop 26, Prop 24, which deals with extremely complex tax issues, and Prop 26, which is broadly written, and both of them would have profited by, it seems to me, the kind of analysis and public hearings that we've had here today in order to make better policy. And we really do need to, I think, everyone understands that our system of governance is pretty dysfunctional and pretty broken at the moment. And I think that reforming the initiative process is something we have to do in order to make better public policy. So good luck, the public, voters who have to choose yes or no on these ballot measures and many others. So with that.
Thank you. With that, we are adjourned.